Incorporation. Jamie Anderson, a partner in the commercial department of a law firm, is discussing the formation of a company in the UK with an overseas client. The regulations for incorporation, that is, forming a company, are set out in the Company Act 1985. There are a number of steps to be followed in this procedure. We offer this service to clients, as do accountants and other private sector formation or registration agents. Firstly, it's necessary to choose a name for the company, which is legally acceptable. The name to be registered isn't necessarily the same as the trading name. The application for registration will be rejected if the name can't be distinguished easily from a company which already exists as a registered company. The use of certain words, for example British, international and European, may require prior approval before they can be used in a company name. Form 10, which gives the names of the directors and company secretary, and are submitted to the Registrar of Companies at Companies House in the respective jurisdiction. On completion of registration, the new company will be given a company number, also known as a registered number, which remains constant throughout its life, and Companies House will issue a certificate of incorporation. In fact, it's possible to begin trading as a company by purchasing a shelf company, which is already registered, and having its shares transferred. This is a route chosen by clients where speed is a prerequisite. A company must have an office in the jurisdiction at which it can be served with any legal process. The statutory books, or official company registers, must also be kept there and be available for inspection. Details of any registered company, its registered office, company number, accounting reference date, date of its financial year end, and history of previous names can be found free of charge at Companies House. When a company is incorporated, it must adopt memorandum and articles of association, also known as the Men and Arts. The memorandum sets out the company's objects or purposes, and it's important to ensure that these properly reflect the company's intentions. For example, the ability to mortgage company property for the purpose of raising finance. The articles set out the relationship between the company and its shareholders. The requirements for directors and shareholders' meetings are also set out here, as are restrictions on share transfer, and allotment of new shares, and regulations concerning directors' powers and duties. Most companies are limited companies, with the liability of members limited to the nominal value of the shares they hold or, less commonly, the amount they guarantee to contribute to the company's liability on liquidation of the company is closed and its assets sold. A company must have a stated number of shares issued to properly identified shareholders. Any company will have a maximum amount of share capital, which can be issued, known as the authorized share capital. A company need not issue all its authorized share capital.